Okay, good afternoon, everybody. We begin this third presentation of the workshop of Quaestio Facti workshop. In that case, with a presentation of Professor Paulo Mendes, who is Professor of Criminal Law at the University of Lisboa. His main interest in research interests are in the fields of criminal law, criminal procedure, and evidence in criminal procedure. And today presents the paper about cooperation agreements and proof, comparative law perspectives. It's a real pleasure for us to have you here in Girona for the first time. I'm sure that will be only the first time in a long series of times. Thank you so much. Your time.
Thank you. First, I would like to thank Professor Jordi Ferrer and the group from Girona for this kindly invitation. I'm sure that in the future we will have more opportunities to develop this scientific and even personal relationship. And my talk today is about a subject not very discussed in these fields, but it corresponds to an ongoing research project developed by my own faculty, the Research Center for Criminal Law in the Lisbon Law School, which that is directed from my colleague, Professor Maria Fernanda Palma, also with CETPAL from Göttingen University, led by Professor Caiambos, and also from Law Faculty of São Paulo University with Professor Marcos Zilli, that is also a state judge. It is an ongoing project. We are going to publish a book in Portuguese language and also in Spanish language. We are preparing the papers from a workshop that happened in Lisbon with colleagues like Caiambos, Stephen Tamen, Massimo Langer, Renzo Orlandi, Teresa Armentadeu, Oin O'Connor, from São Paulo also, Marcos Zilli, Gustavo Badaró, Marcos Veríssimo, and Andrei Borges Mendonça, and other colleagues from Portugal. But at the same time, it's a good idea to spread this discussion, and I asked the permission from my colleagues, Caiambos and Marcos Zilli, to use this English short version from my talk. So, and I feel that it's even to publish if it is worthwhile. I have to review my English first, but let's talk about it. So, cooperation agreements and proof in a comparative law perspective. The main topic of this talk is to show how would it be possible that a bilateral transaction that is a procedural contract between the parties be transferred from an adversarial system in the Anglo-American manner to an inquisitorial system in the continental European manner, which is also the case of the Brazilian system. In the adversarial system, the principle of discretionary prosecution is in force, whereby the conclusion of procedural contracts is accepted to reduce the probative effort borne by the persecutory body and maximize the likelihood of conviction of defendants who, in other circumstances, would hardly be condemned. In the modern inquisitorial system, there are no parties, since the public prosecutor does not pursue a self-interest in criminal proceedings, but only represents the interest of the community in the discovery of truth and realization of justice, which ideally encompasses the interest of the defendant as an accused person of this same community. In this context, the principle of legality prevails, which means that prosecution is mandatory in face of the denunciation of crime. The value and even the legitimacy of the cooperation agreements are debatable in this system where the prosecution has only the path of criminal promotion and prosecution before it. If the advantages of cooperation agreements were not provided for by law, the agreement between the authorities and the collaborator could even constitute a crime of denial of justice by those authorities, despite being able to gather evidence against the collaborator itself and other co-defendants in a criminal case. But the differences between the two major criminal procedural systems are, however, smaller than they seem at first glance. So the possibility of procedural contracts is not incompatible with the inquisitorial system or with cases marked by greater judicial control. So that's the topic and that's the thesis, the main thesis. Beginning with a comparative law perspective. Cooperation agreements are a variant of negotiated justice practiced in the United States of America, or at least a plus in front of the idea of plea bargaining. The difference between the cooperation agreement and the mere plea bargaining is that the former is a tool for investigating associative crimes, whereas the latter is merely a transaction to dispense with proof of crime. In the cooperation agreement, the public prosecutor puts the suspect in the imaginary situation of the prisoner's dilemma game, encouraging him to denounce his partners. While everyone's silence would maximize everyone's advantage on average, the selfish prisoner will gain maximum advantage for himself by giving away the others. This logic can still be iterated successively in a premium ranking system, depending on the chronological priority of the denunciations. This is the best way to foster the race to denounce in the context of wrongful practices with an associative nature. We know this from leniency programs in antitrust law, beginning in the United States, but spread all around the world, even in competition law, in European competition law. The federal sentencing guidelines provide for cooperation through 1. Acceptance of responsibility, and 2. Substantial assistance in criminal proceedings as an exception to the minimum binding penalty for the courts. Italy offers the first continental European example of relevance of the behavior of repentant, pentito, as collaborator of justice, collaboratore di giustizia. The early manifestation in the Italian legal system took place in the 1979, in the context of the fight against terrorism, during the years of lead, Anni di Piombo, marked by bloody attacks and murders from the late 60s, Piazza Fontana bombing, until the early 80s, Aldo Moro's assassination. This legal framework then emerged as an exceptional tool to respond to the menace of terrorism. Anti-terrorist legislation has expanded successively to the fight against organized crime, including anti-kidnapping, anti-drug, and anti-mafia legislation. Who does not remember the first regretful mobster in history, Tommaso Buscetta, detained for the second time in Brazil on October 24th, 1983, and extradited to Italy, where he would collaborate with Judge Giovanni Falcone, revealing the internal structure, recruitment techniques, and criminal plans of Cosa Nostra, the Sicilian mafia. In 2000, Buscetta would end his days in probation and new identity in the United States, where he was voluntarily extradited in exchange for new revelations about the American Cosa Nostra. The expansive trend of the aforementioned legislation had continued to grow to this day, incorporating other domains of repression of associative crimes. However, the legal regime does not contemplate any procedural negotiation between the public prosecutor and the suspect or accused person, and it is up to the court to decide on the awards at the end of the trial. It's not a procedural regime, it's only a material, substantive law regime. Notwithstanding, it's important to mention the need for an agreement for the suspect or accused person to be admitted to the witness protection program through un verbale illustrativo della collaborazione reso da persona non detenuta ammessa al programma di protezione. I did not find many papers on these subjects. It seems like as they are very informal subjects, the literature don't focus on it. So even good publications in Italy don't mention often these verbale. According to official statistics of 2016, only with the collaboratori di giustizia and their families, we have these huge numbers, 1,300 collaborators and 4,700 family members included in these program protections for collaboratori di giustizia. Regarding the year of 2016. Those are public data. You can see them in a report to the Parliament online in open access. It should be noted that the Italian legal system is currently the most adversarial of continental European legal systems, namely from the Code of Penal Procedure Code from 88, from last century. In Germany, there are records of the existence of crown witnesses, Kronzeuge, in the remote times, for instance from the 18th century. But the introduction of the Legalitätsprincip in the Code of Criminal Procedures, Strafprozessordnung, from 1877, prohibit such practice. However, from the 80s last century onwards, sectoral legal regimes were created for crown witnesses. Notably, the Narcotics Act, Betäubungsmittelgesetz, whose original version from 1981 allowed for the reduction or waiver of punishment by the court for those who, on a voluntary basis, substantially assist the authorities in clarifying the crime behind their own contribution to the crime, or voluntarily provide the authorities with information on the future commission of crimes in a timely manner, thus granting that the planned infringements could still be avoided. In 1989, a similar legal regime for organized crime was created, and in 2009, leniency solutions were generally incorporated in penal code itself. Paragraph 46b, where the court is authorized to mitigate the penalty or replace a life sentence with an imprisonment of not less than 10 years for those who make a substantial voluntary contribution to the discovery of a crime related to their own crime, or voluntarily report to an authority in timely manner to prevent a crime related to his own crime and whose planning he was aware of. This provision of the Strafgesetzbuch contains a substantive law regime, but it lacks a procedural law regime. Can the price be combined with the criminal settlement agreement scheme? As you know, the previous informal agreements on the criminal sentence, Urteilsabsprachen, have been legally established and are now called mutual understandings, Verständigungen, from the Mutual Understanding Act, Verständigungsgesetz from August 2009, which introduced a provision on the Strafprozessordnung. But it is not trivial that public prosecutor can promise the suspect at the stage of the preliminary proceedings, Ermittlungsverfahren, the granting of advantage for his cooperation with the criminal investigation, in view of the fact that such awards will be ordered by the court through mutual understandings. Some colleagues of ours will say that if the public prosecutor speaks about during interrogations of this kind of prices, it would be a form of coercion, and it would be the evidence gatherer would be void with all the effects of Beweisverbot or exclusionary rules. Others say that it depends. If he only mentions the law saying that these prices exist, it is not a coercion. But it's a very difficult line to establish what is coercion, what is single information. But we would have to combine Kronzeugenregelung with Verständigung, so the promise from the public prosecutor could be accepted by the fact finder. And that's a path that is not developed right now, perhaps in an informal way. In the Italian and German legal systems, as we have seen, there are no specific procedural regimes for the collaboration of justice, but only regimes of substantive law. Most recently, Brazil has played a major role through the establishment of a substantive and procedural regime for cooperation agreements, colaboração premiada, through law 12,850 from 2013. And the Brazilian legislator has endowed the cooperation agreements of an exhaustive procedural framework, and right now is ongoing, widely applied in so-called Operation Car Wash, Operação Lava Jato. I think that the source of inspiration were various international instruments, but also the North American paradigm of cooperation agreements. That is not totally established, because sometimes people confound cooperation agreements with plea bargaining. And I say that they are separate issues, or at least cooperation agreements are a plus regarding plea bargaining. And it's important to separate them, because the prices for a guilty plea are not exactly the same for giving evidence against third parties. And that's important inside the guidelines for sentencing, guidelines for downgrade the minimum level for the sanctions in the American system. Well, the law of treaties. That is just to mention that we have two important treaties: United Nations Convention against Transnational Organized Crime, also known as the Palermo Convention, that imposes these kind of solutions in Article 26. Many of our countries subscribe to this convention, and many of us don't have this kind of regimes, even if they are there. And also the Merida Convention against corruption as Article 37 with these kind of tools imposing benefits for cooperation agreements. And I think that if we look to the Brazilian regime, many of the procedural solutions are directly in the conventions, even if in most of the European countries we don't have that as a procedural regime. Well, let's begin discussing some of the issues regarding cooperation agreements. I think there is a common problem regarding these cooperation regimes in civil law and common law systems. In both, does not depend of being inquisitorial or being adversarial. Is the problem of the conformity to the purposes of justice. And that problem has to be considered on the side of the law enforcement authorities and on the side of the potential collaborators. Because treating the collaborator as a mere source of evidence for criminal prosecution is not a problem for anyone with a Benthamite opinion of justice, given that increasing the possibility of obtaining more convictions is a sufficient ground to legitimize the cooperation agreement. However, utilitarian ethics, despite its scrolls, does not account for a crucial aspect of justice, which is respect for human dignity. We can discuss on that, because there are very developed ideas of utilitarian ethics that can incorporate perhaps some notion of a respect for human dignity. I remember just the work of Derek Parfit on what matters, that tries to demonstrate that the three main ethics, the ontological, consequentialistic, and the virtue ethics, in the end of the day, defends the same thing, and others try to demonstrate that even Kant was an utilitarian. It was the case of Richard Hare. Well, I don't believe in this kind of perspectives, but I'm not criticizing utilitarianism as per se. I'm just saying that in a strict interpretation of utilitarianism, the absolute respect for the human dignity of a single person is not more important than the imbalance between the interests of community and the individual person. But I try to base this idea of dignity as a status for every human being that implies that the individual to whom the cooperation proposal is made should be treated with respect from the side of law enforcement authorities, so as not to be required to lose faith. And borrowing an expression from Jeremy Waldron that he used in an anti-Foucaultian way, we would say that justice has to pursue a kind of moral orthopedics, preventing its recipients from bending their spine or not walking upright. Now, the invitation to denounce appears to be unworthy because betrayal or someone's surrender has a bad name in the history of Western civilization and does not seem to allow the traitor to walk upright. Judas Iscariot, the traitor, the one who in the Gospels, the one who gives in etymological sense, fell into despair and returned the 30 coins to the chief priests, who refused to put them in the temple treasury because they were the price of blood. And in Spain, you know who it is, Viriato's assassins claimed the promised bride in Rome. The centurion ordered its execution in public with their bodies exposed under the inscription, "Rome does not pay traitors." You can read it in classical texts from Strabo and so on. Thus, betrayal seems to minify those who practice it, and otherwise it seems inadmissible for a society that values loyalty. And I think it is a common problem for Anglo-American tradition or European continental one. So, but we must be wary of the simplifying interpretations of moral histories. Ultimately, Judas felt despair or even remorse because, in his words, he had delivered innocent blood to death, and betrayal tormented him because he was aware of Jesus' innocence. And the chief priests, on the other hand, considered that bad conscience was a traitor's problem, yet they recognized that the 30 coins were a wicked payment. And Viriato's assassins, in turn, betrayed his military chief, someone who was respected as such by Roman invader, although he was an opponent to be shot down as an obstacle to Romanization. For instance, Lucius Annaeus Florus says that Viriato went from hunter to bandit, and from bandit suddenly became a leader. And he was respected as such by the Roman invader, although he was an obstacle to Romanization. The assassins felt no remorse, but Rome knew how to distinguish between the adversaries and mere bandits. In neither case was it a matter of verifying the betrayal itself, but rather the betrayal of the innocent. Even though loyalty is a moral virtue, as opposed to betrayal, it does not exhaust itself, regardless of its object. Even philosophers who praise the value of loyalty to the point of conceiving a duty of loyalty to loyalty, such as Josiah Royce, and of recognizing that loyalty depends on its object and that there are conflicts of loyalty between different people who have to be resolved for the common good. Indeed, absolute loyalty is a feature of totalitarian apparatus as a means of protecting their leaders against external threats. And it's not coincidence that one of the popular designations for the mafia is honored society, honorable società, a sort of guild of loyal individuals, but loyalty of its members is ensured through the threat to their own lives in case of betrayal. The very law of silence, omerta, that subjugates the populations represents the triumph of fear, while the moral value would be precisely in denouncing the crimes committed by the mafia in the populations were not more exposed to the revenge of the mobsters than supported by the protection of the state. So, in a single word, it is not anti-ethics, this proposal of betrayal, and it can be justifiable in ethical terms. So, beginning with more jurisprudential topics. Cooperation agreements are an exceptional means of gathering evidence. But this qualification, being correct, is nevertheless innocuous and has little or no use for clarification of the topic, because it is not exceptional in character like some other means of gathering evidence that are invasive and against privacy of the suspects and third parties, like wiretapping or online monitoring. The only reason why cooperation agreement is exceptional, being an ostensible method, is because of the nature of the crimes about it is used to. It has to be associative crimes. It's not even to be a comparison between felonies or other wrongdoings. It's just the nature of associative crimes because we have someone to betrayal against third parties, partners in the same facts. Cooperation agreements can be transferred to the inquisitorial system. The adversarial system is a process of parties which implies the discretion of the public prosecutor to decide the viability of an accusation based on the opportunity costs in the balance between the investigations to be carried out and the attitude of the opposing party, provided that the object of the process depends on the willingness to prosecute according to the greater or lesser seriousness of the crimes investigated in every case. But in modern inquisitorial system, that many authors prefer to call mixed, reformed, or Napoleonic because it implies an objective distinction between instruction, prosecution, and trial, and a subjective distinction between the accusatory body and the court, unlike the old inquisitorial system, which did not allow such distinctions. There are no parties, since the public prosecutor does not pursue a self-interest in criminal proceedings, but only represents the interest of the community in the discovery of truth and the realization of justice, which ideally encompasses the interest of the defendant as an accused person of this same community. But I have read a German scholar, Michael Bolander, Michael Bolander, that claims that the German prosecutor decides to prosecute on the grounds of his own discretion. The same author says that this is, after all, more or less the same situation that occurs in common law. I'm not sure. I would like to hear from you, from the common law, if it is like so. In Germany, the public prosecution service, if the investigations offer sufficient grounds, genügend Anlass, for prosecution issues an indictment, Anklage, before the competent courts. The ruling opinion interprets this provision as meaning that there is no public interest in an accusation just to clarify the facts by the competent court or even to satisfy the wish of the complainant, Anzeigerstatter, to free himself from the weight of the complaint. The public prosecutor shall accuse under consideration that there is sufficient evidence in reichender Tatverdacht for the court to issue a decision opening the main proceedings. And this is a formula which expressed at the end of the preliminary inquiry, Ermittlungsverfahren, the prosecution's discretion. I don't know if you agree with this interpretation. Comparative analysis between the principles of discretionary prosecution and legality reveals, after all, few differences in practice, unless one wants to endorse the rhetorical effect of the proclamations about the superiority of the principle of legality as a manifestation of the master idea of equality in law enforcement to all citizens. It is therefore not because of the confrontation between discretionary prosecution and legality that it will become impossible to transfer cooperation agreements from an adversarial system to an inquisitorial system. And in short, the possibility of cooperation agreements is not at all incompatible with the inquisitorial system, nor with the cases marked by greater judicial control. Let's now see judicial homologation of the cooperation agreement. I think we can say homologation, judicial homologation. Judicial approval of the cooperation agreement does not affect the contractual nature of the agreement itself. It would only change its legal nature and become authoritative court's decision if the court were to engage in a check on the appropriateness and proportionality of the agreement. But the judge must abide by the terms established by the parties, limiting himself to the legality analysis of the agreement. Let us assume that this is the case, although judges in practice enjoy reasonable discretion in accepting or refusing cooperation agreements, in particular when they reject the agreement because it is not supported by the evidence presented. Judicial homologation ensures external oversight of the balance between the parties in the cooperation agreement, according to legally established parameters. If the homologation solves a problem of legal compliance of the cooperation agreements, it is also true that it triggers at the same step other problems no less serious than the risk of non-compliance with law by the parties. In particular, the approval does not guarantee the impartiality of the trial courts unless the judge who intervened in the approval is prevented from judging the case. That's not the case in Brazil. He is not prevented from judging the case, and he homologates the agreement. Decreeing the judge's impediment is essential as a fundamental guarantee of the impartiality of the trial court. Otherwise, we would be promoting a harmful effect of alliance or solidarity, Schulterschluss effect, it's the name that Schunemann uses, between prosecutor and court perspectives. Let us now see the effects of the refusal of the proposal. Special attention now deserves the refusal of the proposal for an agreement. It is not acceptable acceptable that the statements and pieces of evidence produced by the intended collaborator are not detached from the case file if he or she rejects the proposal submitted to him or her by the public prosecutor or retracts it before the judicial approval or homologation. If the proposal is refused or retracted, the self-incriminating evidence produced by the defendant should not be used to his or her detriment, but evidence should not be used against third parties either. We do not accept that there can be use of the elements gathered in the portrayed negotiation, not even as evidence to be used exclusively against other members of the criminal or terrorist organization. If the agreement was not concluded, then the statements and pieces of evidence obtained during the talks should be destroyed or returned to their source. No agreement, no evidence. The defendant who has given up the collaborative approach does not have to bear the risks to himself or herself and his or her family that would come from his or her eventual collaboration, which would not be the case if the elements he or she brought were in the file for future use as evidence against third parties. If the protection of the collaborator is not sufficiently guaranteed, then the efficiency of the sole idea of cooperation agreements will be severely compromised, as many potential collaborators will outright refuse any exploratory talks with a view to a possible cooperation agreement. So it's not only an argument of justice, but also of efficiency, unless evidence is destroyed if negotiations fail. Here I would like to make a reference to the North American model of informal proffer sessions between a defendant, defense counsel, law enforcement officials, and prosecutors. Steve Tayman was working on these subjects. I discussed with him, and he told me that there is not much literature regarding proffer sessions, something like in a dark zone. Even if there are guidelines about it. In these meetings, informal meetings, but the defense counsel is there, a prosecutor may try to convince a defendant to cooperate by persuading him or her that the evidence against him or her is overwhelming and that cooperating is his or her only option. More often, it is the defendant who must convince the prosecutor that he or she has valuable information and can offer the substantial assistance. This is the concept, substantial assistance. Of course, when a defendant makes the decision to participate in an exploratory session, he or she will have no guarantee of success. On the contrary, a defendant risks completely blindly taking the extreme step of totally self-incriminating, declining the constitutional guarantees of defense that would otherwise be available to him or her. The only protection he or she may get is a proffer agreement. Is a proffer agreement, commonly known, I don't know if you are acquainted with this expression, queen for a day. For me it was a surprise.
That might be new your lawyers, that
Queen for a day agreement, which defines the rules that bind the prosecutor during the interview to the defendant, and the defense counsel is always there, and established that information obtained will not be used later. This is very important to have this kind of protection. You can say, oh, you are the queen for a day, and we are not going to use that. In competition law is like that. I had the experience as head of enforcement in the Portuguese National Competition Authority, and we have to speak with undertakings claiming for leniency in a basis that let's see what we get, and we will use it only if we have, at the end of the day, an agreement, and that discussion can have many days ongoing to decide for.
Why is it a queen and not a king? Does it
Well,
apply only to ladies?
Well, I think that because in England we have a queen right now and for many years, so it could be the explanation. I don't know, because the expression is in the States. I have read it like that.
I think it might be, I would guess more to do with Alice in Wonderland.
Yeah, I was thinking of the Queen.
I would guess it's more Alice in Wonderland, and the idea that when you're queen
Yeah.
for the day, you get to say, you know,
Okay.
the Queen says whatever I
Yeah.
say is true.
Okay,
Yeah.
Alice in
It's that kind of idea,
Wonderland,
but-
Lewis Carroll,
Do you
yes.
know
Okay.
this kind of lawyer's argot, this lawyer's words? It reminds me of things like, do you know the idea of perp walk?
Mhm. Yes,
You know, the
yes,
idea
yes.
that so this is very specific to certain kinds of US bar,
Mhm.
where they have these expressions. But, I mean, it's kind of, it's very much kind of, it's kind of litigation tactics and the kind of lawyer's slang that goes with it.
Yes.
And it's very specific to these proceedings, I think.
To this
I've never heard of Queen for a Day.
Queen for a Day.
But I get the idea.
Yes. And I just had the contact through literature, so I don't know exactly how it works. Even if we have federal rule of evidence 410 and the federal rule of criminal procedure 11F, the plea statement rules, where it is said that statements made by a defendant during plea negotiations are not admissible into evidence. So that this is a kind of soft law guidelines, but they are binding for the law enforcement authorities. So the problem is the way these things are being interpreted, and because following the Supreme Court ruling in the United States versus Mezzanato from 95, the typical terms of proffer agreements now include the possibility of restricting defense guarantees. This doctrine accepts that the defendant may, through a proffer agreement, waive the assurance that his statements will be obliterated should the negotiation fail, thereby admitting that information provided at the proffer sessions will be invoked by the prosecutor at the trial stage itself, although not as evidence, but only as impeachment to statements made by the defendant at the trial hearing, if there is a contradiction to his or her previous statements. This doctrine expanded at the federal and state levels, gradually weakening the guarantees of the proffer sessions to the point of allowing the use of statements made therein at any stage of the criminal prosecution, even if a defendant evokes his or her right to remain silent. The Supreme Court has not upheld this practice, but there is a long list of federal and state court rulings that have already enforced it. More than tools for collecting information, proffer sessions have thus become a strategy for prosecutors to counter and deconstruct the whole range of possible defense narratives. Once a defendant makes the decision to collaborate by offering evidence against himself or herself, there is no turning back. From then on, he or she will be bogged down in a lengthy collaborative process involving reiteration of statements and trial preparation sessions, and all culminating in the obligation to speak at the public trial hearing, in addition to the risk that the court will ultimately consider that it has not rendered any substantial assistance to the outcome of the case, refusing to grant the benefit of the cooperation. So it's a big risk. But prosecutors may undertake, through a substantial assistance motion, to ask the court to grant the benefit to the accused person if he or she meets the conditions agreed, namely to tell the truth. So it's a very complex negotiation. But it's obvious, not only a tool for the prosecutors, but based on equality of arms, a tool for the defense. This is an ongoing process. For instance, in Brazil, the statute law does not say anything about this situation. But there is a joint guideline from the Federal Public Prosecution Service from 2018 in recommendation 40 that says, in the event that the agreement is not concluded, except for absolutely independent lines of investigation, the Public Prosecution Service cannot use the information or pieces of evidence presented by the collaborator for any other purpose against himself or against co-defendants. But at the same time, we have rulings from the Federal Supreme Court that says, literally, the pieces of evidence against third party remain sound, even in the case that there are no deal. So it's also an ongoing disputed process in Brazil. Well, I was speaking about means of gathering evidence. Cooperation agreement as means of gathering evidence. There are another part of the discussion. It's what is the meaning and the nature of the file of the cooperation agreement itself, because there is a dossier as a result of signing the agreement. The literature tends to focus on the collaborators' statements and their probative value, but cooperation agreement file largely transcends such statements, as it constitutes a set of evidentiary elements: the procedural contract itself, the transcripts of the collaborators' self-incriminatory statements or statements incriminating his or her co-defendants, the tapes of the proffered sessions, the documents delivered by the collaborator, which must be kept together. The implications of this dossier extend to the opposing opposing sphere of rights of defense of co-defendants and rights of defenders of the collaborator himself. These two spheres have to be analyzed separately, which I will do next. Well, it's not in the PowerPoint. Regarding the collaborator sphere of rights of defense, it is important to consider the procedural status of the collaborator, the extent of the waiver of the right to be silent and the commitment to tell the truth at the trial hearing, the effects of silence or denial at the trial hearing of what has been said previously, and the failure to comply with the cooperation agreement. Regarding the sphere of rights of defense of co-defendants, it is important to analyze and clarify the legal nature of the collaborator statements at the trial hearing, the need of corroboration of the collaborator statements at the trial hearing by other means of evidence, the right to confrontation or orality, and the collaborator's protection measures, as John has mentioned earlier, the legal nature of the collaborator's statements before the trial hearing, the legal nature of the documents provided by the collaborator, and the need of corroboration of the documents provided by the collaborator. I'm not going to talk about all these issues. Only something about collaborators' right of defense. They should not be treated similarly to witnesses, even if they have to waive the right to be silent and be bound by the obligation to tell the truth. The collaborator has a personal interest in the outcome of the case. He or she cannot therefore have the same procedural status as a witness. The collaborator retains the status of a defendant, moreover co-defendant, until there is a final decision regarding his or her criminal liability. In addition, the collaborator retains the same status if he or she is a defendant in related processes, and even if in the meantime he or she is convicted or acquitted by final decision of any of them. This should be done to avoid manipulation of collaborator's procedural status. Consequently, the obligation to tell the truth assumed by the collaborator can never imply, if he or she does not answer truthfully, the commission of the criminal felony of false testimony. It lacks the quality of witness, which is a necessary element of false testimony. However, nothing prevents the collaborator from committing a slanderous denunciation. In Brazil, the legislator created even a special offense type for the collaborator, as a special case of slanderous denunciation. As for the effects of silence or denial at the trial hearing of the foregoing, despite the judicial approval of the cooperation agreement, the conclusion in principle should be the loss of entitlement to the agreed benefits. But the evidence that the collaborator had already delivered cannot be unraveled and can be used not only against the co-defendants but also against the collaborator himself or herself. In fact, retraction is only allowed at the negotiation stage of the proposal, in which case evidence produced by the collaborator may not be used to his or her detriment or against the co-defendants. The ability to access whether the collaborator's silence at the trial hearing substantially diminishes the weight and importance of the evidence he or she already brought to the proceedings, to the extent that he or she deserves to be paid the price due to his procedural collaboration, belongs to the courts and may be reviewed through appeal, just as it is up to the court to decide whether his or her statements at the trial hearing contradict what was agreed, thus preventing the collaborator from being held hostage by the public prosecutor's interpretations of his or her words, which would be all but innocuous for the defense strategy. So the co-defense rights of defense. If the collaborator is not a witness, statements made by him or her at the trial hearing must be a different means of proof than testimonial evidence. The fact that the collaborator's statements may affect third parties who are co-defendants in the same process, while revealing a conflict of interest with them, is sufficient to require judicial corroboration through evidence that is not weakened in their epistemic reliability. Thus, it is understood that no conviction is given on the sole basis of the collaborator's statements, sole or decisive evidence rule. And the European Court of Human Rights, in the case of Labita versus Italy from 1995, has ruled that statements of collaborators must be corroborated by other independent pieces of evidence. But this is not enough, as it may be necessary to prohibit the valuation of these statements against third parties if the collaborator does not respond at a trial hearing to the questions suggested to the judge by any other co-defendant. Because here there are no cross-examination. The right to confrontation is not based on strict cross-examination, but through the judge. However, we do not believe that collaborator can be subjected to cross-examination, as he or she is not a witness. The prosecutor and co-defendants cannot directly ask the collaborator questions and must request them to be asked by the judge. Even if it is understood that there is no duty for the judge to simply raise those questions, it must be concluded, if those questions were not followed up, that the probative value of the statements thus given may not be equated with that of the testimony of witnesses subjected to cross-examination. In addition, statements at trial hearing made with concealment of reservation of identity cannot have the same probative value as statements of properly identified collaborators. And it is not unusual for this to happen given the commonly established collaborators' protection measures. This can only result in a mitigated confrontation or an absence of confrontation in practice. The statements, on the other hand, made by collaborators prior to the trial during proffered sessions shall not be reproduced or used as evidence. By definition, these statements were not subjected to confrontation by the co-defendants. Such statements fulfilled their role as mere information for criminal investigation and should not be carried forward to trial, except to contradict the collaborators' statements at the trial hearing for impeachment or for rebuttal. Only the documents provided by the collaborator remain in the cooperation agreement file. Such elements are pieces of evidence which must be submitted to the court for scrutiny as pre-constituted or unrepeatable evidence. But do they also have to be corroborated by other evidences? If a document brought by the collaborator would follow the evidentiary regime, then it must be asked whether it may be sufficient in itself for the court to declare a fact as proved. However, this point deserves more careful consideration. In fact, documents delivered by the collaborator did not go through the chain of custody that characterizes the gathering of evidence by the criminal prosecution authorities. No wonder, therefore, that such documentary evidence must also be corroborated, if only through the seizure of mirror documents in such procedures directed against the investigated third parties. It's a common practice to obtain the same documents through searches and seizures on the third parties, locals. But we can discuss, I'm not sure about it, if there is a probative force of the elements collected and preserved privately, provided that it has obtained the notary certification of the document, whether physical or digital. In some places they used to do it as a kind of certification. So, for conclusions, cooperation agreements are a legal institute that is adjustable to the principles of criminal procedure in a democratic and liberal state of law, provided that the guarantees of a fair trial are imposed on it. The guarantees of a fair trial are distributed in two strands: cooperation agreement as a means of obtaining evidence, and the cooperation agreement file as composite evidence. As regards cooperation agreement as a means of obtaining evidence, it is important to highlight its exceptional character, which is why it must obey at the same time the principles of the reserve of law, prohibition of excess, through the legal consideration of its necessity, appropriateness, and proportionality for the investigation of an exhaustive list of serious crimes whose evidence would otherwise be very difficult to obtain, and also the principles of the reservation of the jurisdiction and the natural judge through the court's homologation of the agreement by reasoned decision in response to the promotion of the prosecutor. And last but not least, the intangibility of the essential core of fundamental rights. With regards to cooperation agreement file, it is important to highlight its effects on the collaborators' rights of defense, but also its effects on the rights of defense of co-defendants. In view of the collaborators' rights of defense, the power to assess whether his or her silence at the trial hearings constitute a breach of the agreement to the extent that he or her deserves to be deprived of the price due to his procedural cooperation belongs only to the court and is reviewed through appeal. Considering the rights of defense of the co-defendants, it is undisputed that none of them can be convicted on the sole basis of the collaborators' statements. In all these areas, the practical use of cooperation agreements has not yet been sufficiently scrutinized and criticized by the literature of criminal and procedural criminal law. Such scrutiny would have much to gain if it were done in the light of comparative law and empirical studies. Thank you for your attention.